ATOS. Good morning to the fellow folks out here in California and Mountain Time, including Eric Allen with Allen Mitchell and Allen. I'm Ryan Thurman with Contact Center Compliance, also known as DNC.com. We're a compliance provider that puts on regular webinars. Many of you know we also do compliance summits and provide enterprise-level compliance solutions. And we kind of wanted to end the year with some of the topics that we're getting requests for as far as what they'd like to hear on webinars and get into some of the real detailed issues around TCPA, B2B calls, nonprofit telemarketing, because it is really complicated to try to figure out a lot of this stuff on your own. And you really need kind of an expert to be able to break that down. And so we've got to spend about an hour today going over those types of items. We'll also kind of talk a little bit about recent changes to the FTC's TSR rule. And we're also going to have a little bit of time for question and answer towards the end. So if you have questions, just fill them out on the chat box and go to webinar. We're also going to distribute the slides to this webinar later today, as well as a copy of the recorded version. So if you have to leave early to your company Christmas party, I know that type of thing's going on, feel free. But definitely want to stick around. Got some good information we're going to share with you. So I'm going to go into a little bit about our company, just to give you kind of an update towards the end of the year here. Eric, if you want to move to the next slide. And one of the things we've been looking at specifically is TCPA litigation and where the hotbeds of this type of activity are. And so, no surprise, California, we are number one with, I should say, known litigators, but we know the litigators there, so it's pretty funny. Florida, number two, New York, Pennsylvania, Illinois. These are where we're seeing the most number of what we consider known litigants. These are people who are repeat TCPA filers. A lot of times they'll also file for FDCPA, FCRA. Predominantly, though, you're looking at cases involving cell phone without express consent, using a dialer. So you probably want to either be extra careful in these states or possibly limit, even your amount of marketing. If you are going to market to these states, you definitely want to make sure you're doing a good job identifying cell phones and also identifying any potential litigators, which we can help with, which I'll talk a little bit about in a second. You look at population-wise, based on number of people, Washington, D.C. was number one, then Florida, New Jersey, Pennsylvania, Nevada. So definitely some good information. And we've got also a blog article on our website on dnc.com that's got a little more detail on that.
And Ryan, if I can jump in, the last I heard, roughly 1/3 of those on the professional litigator list were people who had filed more than one TCPA case. So at least 1/3 of the people on this database are repeat filers, not just one-offs.
You see a lot of the plaintiffs coming to your across your desk as repeats, right?
Correct. We get calls every day. Hey, we've been sued by so-and-so, and we know the name most of the time.
So we've been able to, Eric, you might want to move the go to webinar
yes.
over there on the right-hand side. It might block some features.
How about that?
Much better.
I'm still a little flustered about being pulled over on my way here and almost missing this.
Well, we're glad they didn't detain you. It's still early there in Utah, so.
Yeah, I hadn't had the coffee.
So the bad thing is there are a lot of litigators, and they seem to be cloning themselves, as I like to say. The good thing is their phone numbers are identifiable in a lot of cases, and so we've been tracking them and building a universe of phone numbers to use for suppression, either to come through us or do this along with your cell phone scrubs, your DNC scrubs. And so we've got over 89,000 phone numbers compiled. We're adding quite a bit every month, and helpful both on the outbound as well as the inbound side. A lot of these professional litigants like to pose as potential customers, act like they're interested, try to get into some of the lead gen channels. So I kind of want to watch on both sides. And one of the things that's really helpful is to actually run a test. If you're not using the service with us already, just see how many are on the sample. And so we're happy to do that after the webinar today. So just a little bit information on the litigation scrub. We also do VoIP scrubbing, which is related to TCPA, and we also do verification now. So those are some new things which we're doing: disconnect and reassign, analysis on opt-in data, so you can verify the phone number that you have really belongs to that person. So those are the kind of the ways that we're seeing a lot of our customers look for TCPA solutions. Make sure your cell scrubbing is good. Do a litigate search. Make sure you don't have anybody there, and then also verify cell numbers that you do have consent, so you can avoid getting wrapped into the wrong number issue that the FCC has laid down on earlier this summer. So with that, I'm going to turn it over to Eric. He's going to tell you who to watch out for, how to deal with some of these particular issues, and how not to get pulled over.
Thanks, Ryan. Many great compliance solutions at contactcenter.com. I'll preface my portion of the presentation by saying that nothing you hear is legal advice, of course, or even guaranteed to be completely comprehensive, accurate, or up to date. That said, we're going to provide you with a lot of useful information, and the slides will be available afterward. First, quickly, who is watching you? If you engage in telemarketing, telefunding, promoting or advertising over the phone, if you're a call center, a lead generator, a dialer vendor, etc., a variety of different organizations are looking at your conduct. Of course, the big one, the FCC and their TCPA, the Telephone Consumer Protection Act. The FTC, of course, and their rule is the TSR, or Telemarketing Sales Rule. Also, the relatively new Consumer Financial Protection Bureau, or CFPB, the U.S. Department of Justice. You also have state attorneys general and local consumer protection agencies. Note that for several years now, they have been sharing complaint data as part of this Consumer Sentinel system. Also this year, the FTC created econsumer.gov and announced a partnership with, I want to say, roughly 30 or so foreign countries. Also, just as of last month, the FCC has started publishing their unaudited, emphasis on unaudited complaint data online. You can actually go to their website and download a spreadsheet with millions of complaints. They get about 20 to 30,000 a month. You may want to get on there no matter what type of calling you're doing and check your DIDs that you're pushing out on caller ID and see what complaints exist with the FCC. Also watch out for the Neighborhood Watch of Consumer Protection, the BBB, and most scary of them all, private plaintiffs and their counsel who filed TCPA class actions. Okay, this is a great opportunity today. Very often, for-profit telemarketers and debt collectors get all the attention during compliance presentations like this. That is not the case today. We are focusing on B2B, i.e. business-to-business calling, and also non-profit calling, including charitable, political, educational type calls. I'm B2B, so I'm exempt from all this. No, that doesn't apply to me because I only work for duly formed 501c nonprofits. Hey, we're a charity, or we're a PAC, so we're all good. I've heard these things over and over and over. Well, the truth is they're partly right. All these statements are partly true and partly false. The truth is B2B and nonprofit calling are exempt from some, but not all of the rules. And let's talk about that today. And this was really meant to be by a pure act of serendipity and my amazing lawyering skills, including Dimple's puppy dog eyes. I was able to get out of that speeding ticket and make it here just in time to do this. Okay, let's start with B2B. So remember, you've got FTC and FCC, totally different agencies, totally different laws. The FCC's got their TCPA, the FTC has their TSR. So let's talk about B2B and the FTC. In general, B2B is exempt from the TSR as long as you're not selling non-durable office or cleaning supplies. So a cleaning solvent, paper, toner, paper clips, etc. Note that the TSR was just amended, and I've got a final slide near the end of the deck here, clarifying some of this. In particular, what changed was that the FTC clarified if you're calling a business, but your real target is the employee, the individual, and you want to sell them an individual product or service rather than selling something to the business, that also kills your B2B exemption. So two ways to kill your exemption if you're calling B2B under the FTC's rules, the TSR. One would be to sell non-durable office supplies or cleaning supplies. The other would be you're calling a business line, but really it's a solicitation for an individual employee at that business. You need to be selling a business product to a business, and it cannot be a non-durable office or cleaning supply. And this is great in the TSR. It just flat out says the following are exempt from our rules. Telephone calls between a telemarketer and any business except calls to induce the retail sale of non-durable office supplies or cleaning supplies. Again, they added some language which will be in the final slide. Brand new change that hasn't gone into effect but will shortly. Also note that outside of the FTC's telemarketing rules, they have more general fair practices rules, like in the Federal Trade Commission Act about not misrepresenting your offers, etc. That applies to all sorts of commerce, not just telemarketing. Okay, what about the FCC and their TCPA? The TCPA is normally considered a lot more scary than the TSR because of the TCPA's private right of action, meaning it's not just that a government agency can enforce the rules, but any Joe Schmo who you call in violation gets to sue you individually or as part of a class action and get up to $1,500 per individual call, or per violation rather. So what about B2B and the FCC? Well, there's no specific B2B exemption from the TCPA or the FCC rules like there is for the FTC stuff, but there is, unfortunately, a lot of prohibitions and rules that are not consumer specific, so they're broad enough to capture B2B. Here's a little example from the TCPA. All artificial or pre-recorded voice telephone messages shall blah, 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 disclosures, abandonment rules, etc. That doesn't say when calling a residential telephone subscriber or a private consumer. It's just a restriction on the use of autodialers, so that would protect business lines and consumer lines. Most notably, the October 2013 dialer rules and the more recent amendments about what an autodialer is. All of that protects all cell phones, not just consumer cell phones. This is something a lot of our B2B friends struggle with coming to terms with. B2B is not exempt from the cell phone rules. Cell phones have the exact same protection, whether they are a business cell phone or a consumer cell phone. In general, you cannot autodial a cell phone without consent, and we'll talk about what kind of consent. Okay, what's the positive? Well, thankfully, to this day, nothing in the TCPA or TSR bans pre-recorded robocalls to business landlines. So at least at the federal level, and some states are more strict, but under the federal rules, which apply everywhere, business landlines are fair game for pre-recorded messages, as long as you follow the behavioral rules that exist. I'll caution you that it's not always perfectly clear whether a phone number is a business line or not. Also, some states go above and beyond the TCPA and TSR Washington State's a great example. Washington State has a local robocall ban that protects business landlines. But under the federal rules, you can robocall business landlines. You would just need to exclude those states that are more strict and follow some pretty easy behavioral rules. So, for example, those in the bank card merchant processing space, if you're calling to sell merchant processing software, for example, or business loans, for example, or SEO or something, you get to auto dial, including pre-recorded messages, business landlines. You just have to exclude states that are more strict. How do we know the TCPA protects business cells? Well, I try to avoid cutting and pasting long pieces of code, but this is why, because people challenge me on this occasionally. The TCPA says that no person can initiate a telephone call using an auto dialer to any telephone number assigned to a cell phone without consent, period. So not consumer specific. Implications for auto dial calls to business cells. B2B must scrub wireless. Talk to Ryan or your preferred vendor. You need to be scrubbing against at least 2 different files. The wireless block file, or carrier file as it's sometimes called. That's a list of numbers initially assigned to cell phones. And of course the ported cell phone number list, a list of landlines that were ported, that were changed into cell phone numbers. So B2B has to scrub wireless just like B2C when using an auto dialer or pre-recorded message to call a cell phone. Or, what's the alternative? Get prior express written consent. That's the other end run. You can either remove cells in states that are more strict, or you can obtain prior express written consent. With the consumer's written permission, you're allowed to do almost anything you want, including robocall a cell phone. Well, what is this written consent? That was defined in the TCPA on October the 16th, 2013. You can obtain that as long as you have proper disclosures and record keeping. You can do it on a web opt-in, a paper form, through email or text conversations, or a recorded phone call. There are a lot of ways to obtain so-called written consent. The FCC made clear that when they said that, they would include anything that would constitute an electronic signature under the Federal e-Sign Act or similar state laws. And in their own commentary, in the report and order, when they made the 2013 amendment, they specifically said or stated a long list of modes and mediums, including things like websites, recorded calls, etc. So a lot of ways to get written consent, but you need written consent to call a cell phone using an auto dialer. Okay, this is the FCC's long definition of what express consent or express written consent is, but to make it a little easier, this is what you need. The consent language has to identify the particular number, the true marketing purpose of the call. It has to identify which specific business or businesses will call them. It has to be technology specific, meaning you have to tell them if you're going to use SMS versus pre-recorded, an ATDS or automatic telephone dialing system, etc. Also, you must disclose that they are not required to consent to receive your marketing in order to make a purchase, at least if you're doing marketing. You need to collect an unambiguous affirmative agreement evidencing their consent. The FCC specifically said you can't just put this in fine print or in a privacy policy. It has to be in your face, and I would say right adjacent to the call to action or submit/advance button or checkbox. And then you need an electronic signature, which again, many ways to obtain that. Here's a sample that could be on a website. This is for obtaining prior express written consent to allow you to auto dial a cell phone, whether you're B2B or any other flavor of telemarketing that needs written consent. By clicking submit, I agree to be contacted by Allen Legal along with its agents and partners at the number I entered above, which I certify as my own number for marketing and other purposes, including through the possible use of an auto dialer, pre-recorded, and text messages. And then this is just a best practice here, but I'd like to put in, I agree that calls may be recorded or monitored, and I'll update Allen Legal immediately if I change my number. And I'm not required to consent in order to purchase. Submit. Make sure. Again, this is for a website, but this could be adapted for a paper form or any other medium. But on a website, you'd want to capture the URL where the consent was obtained. You would want to time and date stamp the consent, record the IP address. You would want to save a screenshot or similar data that's very user-friendly that you could show a judge and they would get it, showing exactly what the consumer saw when they consented and what they entered into the form. And you want to store all that for at least 5 years beyond the last date you will call in reliance on that consent. Okay, what about B2B and these do not call lists? Ryan's company could tell you all about that. We've got a national list and 12 state do not call lists. Used to be 13. Wisconsin got rid of their state no call list last year. But does B2B have to scrub consumer DNC? Well, certainly these consumer do not call lists were meant to protect consumers, not business lines. But a couple of words of caution. Thankfully, genuine business numbers are not protected by the national do not call list, which has, last I checked, what, Ryan, 70–80% of all private numbers on it now. This means even if you put their, do you know the stats on that? I know once you throw in state, you're looking at 80+% of all numbers being on some DNC list, am I right?
Yeah, I mean, if you take a list and just bounce it on national and state and you haven't really done anything to prior, you could lose 80–90% easily. You got a total of 223 million on the Fed list, and then you've got a huge chunk out of the 12 states that are still out there. Florida's got like 14 million.
Huge
Texas
list,
has got 14 million. So
the good news is, in general, pure, genuine business lines are not protected by the national DNC and most state DNCs. That means even if I go on the FTC's website and put my business line on the national DNC, there's nothing preventing me from doing that, but technically it's not a violation to call it. But here are my words of caution. Why should B2B still scrub consumer DNC? Well, that's for at least 2, maybe 3 reasons. First, not every state no-call list has a clear B2B exemption. Some of them definitely don't. For example, Utah state law makes it illegal to call numbers on the national do not call list. And Utah has no B2B exemption. So they say, well, we default to the national do not call registry. You can't call it or it violates our local rules. But then they don't, unlike the feds, they don't include a B2B exemption. That's the case for a number of states. Also, Colorado specifically has a Supreme Court case from about, I want to say 6 or 7 years ago that specifically held that its state list protects home-based businesses. So reason number 1 why B2B should scrub consumer DNC is that state level issues. Not every state has a B2B exemption, and in fact some states specifically try and protect certain business lines with their list. Also, a bigger problem, dual purpose lines. There are a lot of, if you buy a business list, I guarantee you not all of those are truly, purely, solely business lines. A lot of them will be dual purpose lines, or it will be a private line where the actual subscriber is Eric Allen, not Eric Allen Inc. And they used it for certain limited business purposes for a time, and now they're just using it for private reasons, and they don't want to receive B2B calls. They want to be protected by the do not call list. Also, I don't have a bullet point for this, but it's really hard to tell whether, for sure whether a line is owned by a business or a person. There are some scrubs you can buy for that, but they're not 100% accurate. So just, if you're B2B, you really need to be scrubbing consumer DNC anyway. And honestly, it's a great way to cut down on instances where you would accidentally call a consumer thinking it was a business. If you're calling B2B, you want to talk to businesses. You don't want to talk to some old grandma sitting on the porch and try and sell her merchant processing software or a business loan. No, you want to talk to an established business. So scrub consumer DNC. The one bonus is, at least for the federal do not call list, which is over 16 grand annually now, you can get a free SAN number and download that entire list for free and then scrub in-house or use a great vendor like Ryan's company. So B2B, go ahead and scrub consumer DNC. B2B is exempt from many, but not all, state telemarketing licenses. There are, I want to say about 32, 33 states right now that have some form of local telemarketing license and/or bond. Each state has a ton of exemptions. The states where there is no license, I would call those the free states. Of course, B2B can call there without a license. But note that of those 33 or so states that have licensing, on top of any other exemption you may have, and there are many, you would also have a specific B2B exemption in a whole bunch of states. I have those in bold here under the second bullet. Be careful, don't just rely on this slide because some of these have caveats. For example, it might say B2B is exempt from our licensing if you've been operating in our state under the same business name for at least 5 years and blah, 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 blah. You know, so there may be some caveats. You need to read the code or talk to counsel to confirm your exemption. But this should be a good push in the right direction. B2B is exempt from a ton of licensing obligations, which is great. Check out, I don't have it up here, but our firm has a free 50-state chart on this at telemarketinglicenses.com. Telemarketinglicenses.com. Nothing fancy, but a lot of great free information on a state-by-state basis. Okay, let's move on to nonprofits. Enough of B2B for now. What about nonprofits like charities, political organizations, etc.? In general, nonprofit calls, whether political, charitable, educational, etc., no matter the category, if they're nonprofit, they're treated basically the same under the TCPA and TSR. Nonprofit calls are exempt from many, but not all of the rules. I got these slides out of order. But let's first talk about the FTC's jurisdiction over nonprofits. The FTC in their rule, the TSR, Telemarketing Sales Rule, by its own language, does not have jurisdiction over nonprofit organizations. Remember that. The FTC has no jurisdiction over nonprofit organizations themselves. Therefore, nonprofit orgs, whether charitable, political, etc., are not required to comply with the TSR, but this is the catch. The FTC does, however, have jurisdiction over third parties that work for profit who might contract to call for the nonprofit. So a third party for-profit telefunder, for example. Now the FCC has broader jurisdiction than the FTC, including jurisdiction over nonprofits. And nonprofits are therefore not exempt from the TCPA. Not all of it anyway. Let's talk about it. So, nonprofits, not subject to the FTC, but your vendors are, your for-profit vendors on some level. But with the FCC, they have direct jurisdiction over all nonprofit calls. You have to play by many of their rules, unless they specifically say you don't have to. The TCPA includes a number of dialing restrictions that are applicable to calls by or on behalf of nonprofits, so whether it's a nonprofit or the vendor. What's a telephone solicitation under the TCPA? We need to understand the rest of the rules and slides. A telephone solicitation means the initiation of a telephone call or message for the purpose of encouraging purchase, rental, investment, which is transmitted to any person, but it does not include a solicitation by or on behalf of a tax-exempt nonprofit organization. Why is this important? Well, some of the rules in the TCPA only apply to soliciting, telemarketing, advertising, etc., and some of them do not. So you'll need to look at your nonprofit call and figure out, is it a solicitation or not? Also important, is it telemarketing or not? Is it advertising or not? Okay. Do the do not call provisions cover solicitations for money, charitable donations? Charities that are calling on their own behalf to solicit do not need to scrub against a national do not call list. This is awesome. Nonprofits do not need to scrub against the National Do Not Call list as a general rule. However, if a private third-party marketing vendor for the nonprofit is calling for the charity, they must at least maintain an internal Do Not Call list. So again, the third-party vendor does not need to scrub National DNC, but they need to maintain an internal opt-out list and honor a request never to be called again, or be fined by the feds up to 16 grand a call. So, again, to summarize, this is very important. Charities and other nonprofits don't need to scrub against National DNC, and neither do their for-profit vendors. But the for-profit vendor must honor an opt-out, an entity-specific internal DNC request. How do you qualify as a nonprofit under the TSR? Remember, the TSR is the FTC's rule. I know I'm jumping back and forth a bit, but to make sure you're outside of FTC jurisdiction, how do you know? Well, you cannot be organized to conduct business for profit or for the profit of the members. This is not exactly the same as the IRS definition. So certainly talk to your CPA, but also talk to counsel about these TSR rules. An organization that has been incorporated as a nonprofit or recognized by the IRS as tax exempt is not necessarily exempt in the eyes of the FTC. In fact, the FTC, just within the last year, successfully brought a big lawsuit against a nonprofit who was relying on the nonprofit exemption to the National Do Not Call list, when the FTC decided, you know what, this is a ruse. You're really operating for the profit of the business or its members, so be very, very careful. If it truly, in fact, in practice, in reality, is operating for the profit of members, officers, affiliates, etc., then even if you keep your tax-exempt status, the FTC could challenge your exemption. Okay, what about telefunders? People calling saying, hey, donate money to my PAC, or hey, donate money to this cancer organization, etc. Telefunders are prohibited from making a false or misleading statement to induce a charitable contribution, making misreps generally, engaging in credit laundering. Obviously, this is common sense stuff. Placing cold calls that deliver pre-recorded messages, engaging in acts defined as abusive in the TSR, like calling before 8 a.m. or after 9, data breaches, not honoring a DNC request, etc. These are rules that private for-profit telefunders must follow. Because remember, for-profit telefunders who work for nonprofits still have to follow the TSR and the FTC, not just the FCC and their TCPA. Okay. You can't misrepresent the nature, purpose, or mission, the tax deductibility, the purpose of the contribution, the percent that goes to the charity, any material aspect of a prize promotion, and of course you can't lie about your affiliations, endorsements, sponsorships, etc. Common sense stuff. These are things that your for-profit telefunder must follow. And under the TCPA, the charity itself, which is subject to FCC jurisdiction, cannot make any misrepresentations. Okay, let's talk about a few scenarios to make this a little more practical, user-friendly, and understandable. And let me check the time quickly. Okay, we're doing good. It's 11:35. Scenario 1. The nonprofit itself makes its own robocalls on its own behalf for informational or political calling only, meaning they're not telemarketing, advertising, soliciting. They're just saying, hey, vote for Eric Allen, or hey, remember election day is X. So no telemarketing. What applies? Well, the FTC has no jurisdiction because this is the nonprofit itself calling on its own behalf. So the FTC has no jurisdiction at all. What about FCC? The FCC does have jurisdiction over nonprofits, but here the nonprofit's not telemarketing. Remember, it's not soliciting, really. Nevertheless, some of the TCPA rules still apply. i.e., most importantly, you cannot auto-dial a cell phone without express consent. You don't need that nasty high-level written consent, that big long definition with all the million elements that we looked at before. You just need express consent. It's easier to get. It doesn't have to be written or recorded necessarily. You can also get it in kind of an implied way if they provided their number to you in the normal course of business without conditions and have not opted out. I've got a slide on that in a bit. What is express consent for a nonprofit? Okay, also, you don't get this 15-day, at least arguably you wouldn't get the 15-day safe harbor for the calling aborted. You are not allowed to tie up multiple business lines simultaneously. You cannot disconnect an unanswered telemarketing call prior to at least 15 seconds or 4 rings. And honestly, if you're not telemarketing, that one's not going to apply anyway. You cannot abandon more than 3% of answered telemarketing calls. So it's if you're using a predictive dialer, you're subject to that 3% abandonment rate. By the way, that is calculated as follows, and the FTC and FCC both agree on this now. That abandonment rate, when you're dialing on a predictive dialer, calling more lines than you have live agents using a predictive algorithm, trying to connect the answered calls to the live agent if one is ready, you're going to drop some calls. You cannot abandon more than 3% of all answered telemarketing calls as measured on a successive 30-day basis per individual calling campaign. So those of you using a predictive dialer, watch out for that. Also, you cannot use any technology to call a number to determine whether it's a fax versus a voice line. And you're required to disclose the name of the entity responsible for initiating the call and the telephone number of the responsible entity. So, scenario 1 again, a nonprofit's robocalling on its own behalf to make informational or political calls. There are a few rules you need to follow, even though you're exempt from all of the FTC rules and some of the FCC rules. And again, the slides will be available. Don't try and write this down. Scenario 2, little different. The nonprofit entity robocalls on its own behalf, so it's making its own robocalls still, but to raise money. They're telefunding. They're saying, don't just vote for Eric Allen, donate to his PAC, or donate to this charitable organization or educational trust or something. So the nonprofit entity is robocalling on its own, but it's telefunding now. Well, it's still exempt from the FTC and its TSR. Why? Again, because the FTC has no jurisdiction over nonprofits. Now, turning to the FCC and the TCPA, if the call still contains no telemarketing or advertising, then the same TCPA rules would apply as in scenario 1. But if it is construed as telemarketing or advertising, which if you're telefunding, it might be, for example, if you're selling something, sort of like if you're saying, hey, buy this be cancer-free sweatshirt and a percentage to our fund or whatever, then you're telemarketing. If you're promoting a product or service offered by the nonprofit, for example, you're telemarketing. And if you're telemarketing, in addition to these 7 rules, the nonprofit also has to follow these 2 bullet points at the bottom of this slide. Again, arguably they lose that 15-day safe harbor, so be extra careful with cells, and the calls must include an automated, interactive voice or key press activated opt-out mechanism. As a best practice, anyone robocalling, even if you're exempt from some of the rules, should be using an opt-out mechanism as a best practice. But it's specifically required if you're telemarketing, even if you're a nonprofit. Okay, scenario 3. Big difference here. This is not the nonprofit calling. Scenario 3 is a for-profit vendor. So a third party who is contracted with the nonprofit is making informational or political calls. So there's not telemarketing or asking for donations, it's not telefunding, but they are a for-profit entity calling to say, hey, I'm calling on behalf of this nonprofit. We want you to vote for Eric Allen. Well, you're going to be exempt from the FTC because there's no telemarketing involved. Remember, the FTC has no jurisdiction over the nonprofit directly, plus they only regulate telemarketing. So ignore the FTC. But under the TCPA, the for-profit vendor has to follow these same rules, these kind of seven things. Can't auto-dial cell phones without consent, can't tie up multiple business lines, you got to follow the call abandonment stuff, certain disclosures, etc. Okay. Scenario 4. This is kind of the most aggressive flavor here. The for-profit vendor robocalls on behalf of the nonprofit to raise money. So it's telefunding and possibly telemarketing. The for-profit third-party vendor is calling to raise money. They're telefunding. They're not just saying vote for Eric Allen. They're saying donate to his PAC. Now the FTC gets jurisdiction. The TSR applies. This is a for-profit private telemarketer in the eyes of the FTC. If you're telefunding, they suck you back in, even if you're working for or under a contract with a nonprofit. And the same rules would apply for those calls as for any other telemarketer, with 2 exceptions. Even in this case, the for-profit vendor does not have to scrub against the national do not call list. This is great. The for-profit marketer is telefunding, and it's the one initiating the calls, not the nonprofit, but it's for the nonprofit, and so you don't have to scrub DNC. Again, make sure the nonprofit truly is not operating for the profit of the business or members in the eyes of the FTC, not just the CPA, although start by talking to the CPA. Also, the for-profit vendor, of course, is banned from making a long list of misrepresentations. Also, all of the rules from scenario 2 would apply, and the for-profit vendor is required to maintain an internal do not call list. So all of this applies. Well, I should have said from scenario 1, all of these apply as well. The call abandonment stuff, the not auto-dialing cell phones without consent, etc. Plus, no misreps. Or I'm sorry, you have to maintain an internal do not call list. So this is the one where you must expressly maintain an opt-out list. How do nonprofits obtain express consent to call a cell phone? Well, it's much easier than B2B, who needs written consent to auto-dial a cell phone. And remember, written consent is that long, convoluted definition with all sorts of disclosures and stuff, but nicely, or thankfully rather, the FCC said you can get it in a bunch of different ways. Well, this is even simpler. The TCPA doesn't define express consent, but one of the seminal cases in this space, the Satterfield case from 2009, said that express consent is simply consent that is clear and unmistakably stated. Also, the FCC threw us a great bone here. And this seems like kind of an oxymoron, but the FCC says you can have implied express consent. I know that's weird, but we're not going to argue with them. The FCC says that you get implied express consent based on the provision of the number. Again, this is for nonprofit and non-marketing calls only. This is what the FCC said. People who knowingly release their phone numbers have in effect given their invitation or permission to be called at the number which they gave, absent instructions to the contrary. The implication is that, let's say the charity has a membership base or has a database of people who have interacted with the charity on some level and provided their telephone numbers. Well, the FCC believes that if someone gives the nonprofit or its agent their cell phone number in the normal course of business without conditions, and they haven't opted out, then you get implied consent to auto-dial that number until they opt out or their number is reassigned. Let me say this once more. This is very important. People who give their cell phone number to the company in the normal course of business without conditions are callable. They have provided implied consent until they opt out or their number is reassigned. Important to do reassign number scrubbing. Do some list hygiene if you're going to call on old data. Some frequently asked questions, and Ryan, I will try and save the last few minutes for some questions like usual. But here are some frequent ones that I know we would be asked. So, Eric, I hear all this legal mumbo jumbo. Just tell me straight up, can charities call cell phones? And if so, what about using an auto dialer? Yes, charities can call cell phones unless they use an auto dialer, in which case they need express consent. But remember, express consent can be implied by the provision of the number. If they gave the charity the number and haven't opted out, then you get to auto dial it. This means if charities are calling using an auto dialer or ATDS, automatic telephone dialing system. Don't even ask me what that means. We could do a whole webinar on that, but it's essentially a predictive dialer, a dialer that could do random, sequential, or predictive if you told it to, any dialer that could dial without human intervention, any dialer that could dial thousands of numbers in a short period of time. In July of this year, the FCC said that whether something is an auto dialer is determined on a case-by-case basis. There are not a lot of bright line tests except for certain things like all predictive dialers are auto dialers. All dialers that can dial without human intervention, if told to, are auto dialers. Beyond that, if you have some sort of manual preview click-to-call system, you need to be very, very careful. Some of those are auto dialers and some of those are not. That's determined on a case-by-case basis. You need to look at the level of human intervention involved. You need to look at the capacity and even the future capacity, which was a big issue in the July FCC ruling. Be very careful. Talk with your developers and tech guys and also your legal counsel to determine whether you really are using an auto dialer or not. One way to get around the cell phone rules is not to use an auto dialer. Another way is to get consent. Okay, so either with or without consent, scrub for reassigned numbers is a best practice. Every day, a lot of telephone numbers are reassigned. Even if you had consent to call person A, if you're trying to call person A and person B answers, who is the new owner of that number, you're liable after the first call. You get one free pass on the calling of a reassigned number. But what sucks is that rule is the same whether they answer the phone and tell you it's a reassigned number. So let's say you get consent to call telephone number A or person A, and you make 20 calls, and then they answer and say, wrong number. Well, that's 19 violations because you only get one free pass. So do reassigned number scrubbing. Get some list hygiene if you're calling on a number that you collected many months or years in the past. Okay, Eric, do nonprofits need to scrub against state and federal do not call lists? I wasn't totally clear. You confused me with some of the weird stuff you said about B2B. Do I need to scrub DNC if I'm a nonprofit? Not the national do not call list, no. Charities and any nonprofit really, and their vendors calling on their behalf, as long as you're following all the other rules, do not need to scrub against the national do not call list, that whatever it was, 220 million numbers on the national DNC. You do not need to scrub that. But your private vendors do need to maintain that internal DNC, and the nonprofit should as a best practice on its own anyway. The for-profit telemarketing vendor of the nonprofit must maintain the internal do not call list. What about the states? Well, like with B2B, states are all over the board regarding whether they want a nonprofit to scrub against their local DNC. Nonprofits are exempt from most state DNC laws, but not all. And some states have specific requirements that nonprofits have to meet to be exempt. I cannot list every state in a short presentation like this, but an example: Arkansas's local state-specific do not call law only exempts persons calling on behalf of a nonprofit who receive no compensation. So be very careful with state do not call lists, as state DNC programs are, they vary as to how they deal with nonprofits. Thankfully, the nonprofit is exempt from the big nasty national DNC and most state lists. So consumer DNC is a very minor issue for nonprofits, like B2B. Exempt from most do not call stuff, but not all. States whose state, and this is the best we could do on this, and this is not meant to be totally comprehensive. Always talk to your own legal about compliance decisions, but this will be a push in the right direction. These are some states whose their local DNC laws do restrict solicitations for donations by a charity. You've got 3 states there. By a professional profit fundraiser, you've got 3, 6, 8, 9 states or so there. What about states whose do not call laws apply to calls for the sale of goods or services? What if the nonprofit is selling something to raise money? What if it's telemarketing and selling something? Well, there are some lists there. Again, look at that, but then be sure to look at the actual code or talk to your own counsel. What else? Are calls by or on behalf of a nonprofit org exempt from state robocall bans? People forget about state robocall bans or just don't think they exist. The big nasty one is in the TCPA, of course. That's the one all these class actions are being filed under. But what about states? Well, like with DNC, the states are all over the board about whether their local robocall and dialer rules apply to nonprofits. This slide has, again, kind of the tip of the iceberg here in terms of information. But do note that there are a lot of states that exempt nonprofit robocalls and some that do not. Come back and look at these slides more later and compare that against your calling strategy, and then talk to your experts to confirm exemptions. Do charitable telefunders need telemarketing licenses? It depends. Usually not. Like B2B, nonprofit telemarketers are very often exempt. But watch out for charitable soliciting licenses. Aside from the 33 or so states that have a telemarketing license or bond, some states have created a special, separate license for telefunders, for example. Do a good 50-state analysis. Okay, finally, before we start taking questions here, Ryan asked me to throw in an update. The FTC, of course everyone's heard that the FCC had ruled on a whole bunch of TCPA petitions in July, and that was a big deal because they expanded what an autodialer is, they clarified their reassigned number rules and all sorts of things. But more recently than that, the FTC amended their TSR, the telemarketing sales rule. Some of the rules go into effect in June and some in February. So the following don't go into effect until June. The amended TSR bans a variety of what they feel are aggressive, kind of sketchy payment mechanisms. These are for telemarketers. So they ban remotely created payment orders and checks, cash-to-cash money transfers, and cash reload mechanisms. Also going into effect on June 13, changes that limit the exemptions for some of those payment methods that existed previously. All the other changes go into effect on February 12th. Those include a requirement that if you're the type of telemarketer that is charging someone's account and is required to have express verifiable authorization to charge the account, during that recorded part of the call, you also have to record the description of the goods and services. So you can't just do your pitch and describe the product and then turn on the recording for the to charge their account. You've got to put the description of the goods and services in that same recording. Again, this is only for telemarketers who are subject to the TSR and only for certain types of transactions, only those that require quote-unquote express verifiable authorization to charge an account, like an ACH charge. Also, in their amendment, the FTC lists a bunch of prohibitions about telemarketers not being able to make it hard for people to opt out. I didn't include the whole list, but you have to make it easy for people to opt out. It has to be a free one-step process. You can't hassle them. You can't make them continue to listen to the solicitation. You can't make them provide a bunch of extra information other than just their telephone number, etc. You have to make it easy for them to make a DNC request. Also, and everybody had assumed this anyway, but the FTC clarified that it is always the seller or telemarketer's burden to demonstrate they have prior consent or an established business relationship exemption when calling people on the DNC list. Remember, B2B and nonprofits generally exempt from the DNC, though. Let's see, what else? I'm trying to think what's most important here. Oh, for B2B, I mentioned this earlier. The FTC clarified that for B2B, B2B is only exempt when it's selling something other than non-durable office supplies, but the addition to the rule was that you can't be calling a business line to try and sell something to an employee at the business. It has to be a true business solicitation, something the business will buy, not the individual. And they emphasize that sellers are prohibited from sharing the cost of the fees to access the DNC registry. Ryan, are there any questions?
Yeah, we actually had quite a few came in. I was trying to hold them to the end here so we can kind of get to the bulk of the presentation. This is actually very helpful because we oftentimes get the same types of questions, and it's hard unless you've done the research, have a good attorney that can look the stuff up to really get the right information when there's so many different interpretations and state rules and just
it gets
a little
pretty
bit of confusion.
Convoluted. Yeah. Well, and even myself, like today, driving over here, getting pulled over, I was on the phone with Scott, my brother and one of my law partners, who's an expert at this stuff, and we're still trying, quizzing each other and trying to remember what's the rule on that weird situation. This is very complicated. It needs to be reviewed over and over. Keep attending things like this, but let's take some of their questions.
Yeah, definitely. And the other thing that really helps beyond the webinars, usually for a lot of people who've come out to our compliance summits, we have Eric and a lot of times another couple of guest speakers talk about more intricate details. We get a really good Q&A going, and makes it kind of fun too to kind of network and meet other people in the industry.
Oh, we always have a good time. We learn a lot. We network. We do business, and we socialize. And I look forward to the next one. Where's the next one going to be?
We're looking at Salt Lake City for early next year or Scottsdale, and then we're going to go from there. So we're just putting the final details together. We just got done with our
okay. These are for the live event.
Yeah, so we usually get a good crowd, usually 75, 80 people or more. Spend the day together, do a networking reception, and go through much more detail about TCPA, TSR, do not call rules, state rules. And so
yeah, it's a full day. We usually do half a day on TCPA and the private class actions and stuff, and then the other half the day on the TSR and state stuff, and then a bunch of other issues.
So yeah, let's get into questions, starting from the beginning here. Well, back to the B2B and the FTC issue. The question was, what if the customer gives you a work number but does not tell you it's a work number? So can you call them directly to offer them something, not the business?
So, a couple things. If someone gives you permission to call their telephone number, and if you can document that, permission gets you around the do not call list and a host of other exemptions apart from your B2B exemption. So if this is someone saying, call me at this number, you're generally going to be fine if you can prove it later. If there's no consent, if they just provided the number, then it depends. If it's a cell phone and you want to auto dial it, no go. You need very express written, emphasis on written, or an electronic signature after significant disclosures. You need written consent to auto dial a cell phone. I hope I'm answering that question right. Or rather that I hope I understood it right.
Yeah, I think the question was really like, if somebody doesn't tell you it's a work number, but it is a work number, does it give you an exemption?
Oh.
What to look out for.
Yeah. Yeah, so let's say you're not really B2B, you're calling B2C, and then you get a demand letter saying, you call this number, I want $4,500 for the 3 calls. But you get online and it turns out you find evidence that it was actually a business number and you can prove it. You may be exempt from the do not call violations, for example. Honestly, if you're B2B though, you should scrub consumer DNC. And you should also do some work with like a list hygiene vendor to find out whether a number is really a business or not. Don't just buy a business list believing that there are no private lines in there. You can do scrubs, which they'll go to the carriers and look, does this particular line, they'll look at the subscriber, the owner of the line, and they look to see, is it Eric Allen or is it Eric Allen LLC? And so they can, if it's Eric Allen LLC, with almost, certainty that it's owned by a business, unless someone named their kid LLC or something. So do some good scrubbing and scrub consumer DNC anyway. Don't just rely on whether or not they told you something.
What's crazy is if you scrub a business list on the National DNC, it's pretty common to lose even 50% to the DNC,
yeah,
even on a B2B list, which tells you, these are businesses that have put themselves on the national list. Maybe they're technically exempt. Problem is that a lot of those numbers are probably not even worth marketing to.
Yeah, and a lot of them are dual-purpose lines. I mean, a lot of people, especially who operate small businesses, their personal cell phone, which they own on an individual level, is also the number they hold out for business purposes. It might be their business line on their business card, on their website, and business directories. Be very careful. A lot of people are doing business on a dual-purpose line. It is not safe to call a dual-purpose line unless it happens to be a landline that's not on the do not call list, and you're going to call it live.
I don't know if you remember hearing the FTC commissioner that said one time, if there's a business number on the National DNC, yeah, we expect you to honor that in front of the whole industry less than a couple years ago. I mean,
yeah,
they were like, oh, whoa.
I mean, that was pretty careless because the statute actually provides no protection for a pure business number. If it's only a business number and not dual purpose and it's owned by a business, it's on the National DNC, it is not a violation of the law to call it. But yeah, there's commentary from the FCC saying they don't want you to. So B2B should scrub consumer DNC, absolutely. And we are defending 2 class actions right now on this issue. They are both cases where an individual used a private line for some limited business purposes, and then when he got B2B calls, one of them was for credit card processing software, filed a big giant class action saying you've been calling people on the National Do Not Call list. And the other one is you've been robocalling private lines. These are not just business landlines. And it's a big fight. And who knows what the judge will decide. Is this line more of a business line or more of a private line? Don't put yourself in a situation where you have exposure on that issue. Scrub consumer DNC. Also do some scrubbing with some hygiene vendors to determine who who really owns the number. Is it really a business line or is it really a private line?
And you talked earlier, Eric, about robocalls. What are the states that are some of the more restrictive ones that people should watch out to if they are going to go down that path?
Yeah, so roughly, well, almost all states have some local robocall rules. And I would say roughly half of the states don't have any clear B2B exemption. But the worst of the worst of the worst, I would say, are right now Indiana and Washington State. There's probably another 10 or so that are pretty bad, but I don't want to try and do those off memory. But Washington State has a local robocall ban that protects businesses, and there are a ton of class actions in Washington State which don't even talk about the TCPA. They sue under this state robocall law on behalf of local businesses. So if you're B2B robo, don't call Washington State. Don't call Indiana. They hate robocalls so bad, even if you think you're exempt. You're going to make some mistakes and have a run-in with them and pay the AG a lot of money. And there are a number of other states that are almost as bad as those two. Get with us afterward if you want more advice on that. But those would be the worst two, in my opinion.
Here's a good question on the B2B aspect. What if the B2B is not covered under the TSR? What responsibility is there to honor a DNC request made to a specific company taken from a business?
So Scott, correct me if I'm wrong, but even if it would be a best practice and strongly recommended, because B2B is exempt from the TSR as long as you're not selling toner or trying to sell some individual something to the employee, the TSR's opt-out rules simply do not apply to B2B calls. Now, you want to know a great way to tick people off and have a lawsuit that's really expensive even if you do win? Keep calling someone after they tell you to stop calling. So even though technically B2B is going to be exempt from the TSR, including the opt-out stuff, you should have an opt-out anyway. Absolutely. You have exposure there. Plus you've got TCPA to worry about, and there are less exemptions there.
How about this question here was about the complaint information. Actually, when you were talking about that, Eric, I put up on the chat, and I can also email this out, the actual link to the FCC's complaint data. So you can go download it. It has quite a bit of information in it, and these are raw complaints that the FCC is now publishing on robocall data with caller ID information of the company that is complaining about, or sometimes they're blank, but it's pretty detailed, and there's quite a bit of information.
Yeah, I mean, if I remember right, they have 7 or 8 categories of data they release about the complaint. They have the date, the cell phone number, the number that appeared on their caller ID, the number the live agent said, the type of call, if it was a robocall, which type, predictive versus pre-recorded, etc. A lot of information is being released, and a lot of it may be inaccurate. They don't audit it. They just dump it right into cyberspace, and any plaintiff's attorney who gets one client can, say, hey, what number showed up on your phone bill, and we're going to go look on this database and see if there are a lot of complaints about that DID.
Yeah, the count on it now, you got 35,901 numbers on this. I just downloaded it just the other day, so that's available.
they're getting, it is massive. That spreadsheet, if you download the entire file, is pretty big file. And they release that, I want to say, weekly. It's a weekly file, and they're massive. A lot of complaints they're getting. A lot of about robocall, a lot about refusing to honor a do not call request.
Makes sense. What about the consent that you need for TCPA? Can that be part of a free offer for a product? So you offer free paper clips, ask them to click the submit button, then consent pop-up appears with another submit button?
Yeah, if you do it right. Excuse me. So you just need to be careful. You cannot require them to consent to your marketing in order to buy something, but nothing says you can't bribe them. So my opinion is, hell yeah. Offer them some free thing and say, hey, we're going to give you X if you let us robocall you for life. That's fine. Now remember, people can revoke consent later at any time and in any reasonable manner. Also, you didn't really get the proper consent unless you have proper disclosures and record keeping. There are certain things that you have to say and certain level of affirmative action you have to get. These are the things, you know. This is a good sample. But yeah, if you have this right under your, hey, get a free coupon in the mail. But by the way, when you click get my coupon, I'm agreeing to be contacted by OnLegal, blah, 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 and I'm not required to consent in order to make a purchase. And then if you capture all the right information, you've got their consent, you get to robocall them. Make sure you're able to prove you had consent. Half the battle is being compliant. Arguably the more important half is being able to prove it years later when you get served with the subpoena or lawsuit.
Here's the question of the day is, and I'm pretty sure you covered it, but I think this is a good example. It says, if a business-only advertised number is a cell phone, can that number be used for calling via a dialer?
No. So all cell phones, even if they're held out to the general public on a website, or maybe you're trying to call like insurance agents or real estate agent licensees, and you scraped a state public database of all their numbers or something. Just because someone holds their number out to the public in some sort of business context does not give you permission to auto-dial it. All cell phones are protected by these really tough TCPA rules. Remember though, for non-marketing and for non-profits, in either category, you get implied consent to auto-dial the cell phone if they gave you the number, not just held it out in a business directory or website or something, but if they provided the cell phone number directly to the charity, for example, or to the political PAC in the normal course of business without conditions, and they haven't opted out or had their number reassigned, you get this implied consent. But no, merely because a business is using a cell phone, that gives you no consent to auto-dial it. You can call it live, manually, the old-fashioned and efficient way, though, if you had to.
What about the DNC? Nonprofits and their third-party fundraisers do not need to scrub against the federal DNC, but I was under the impression that there are several states that do not exempt from DNC calls made by a telefundraiser to solicit donations, such as Indiana, Louisiana,
correct.
and Maine. That's correct?
Yeah, correct. So I'm not sure. Oh, here we go. So, yeah, just make sure you do your don't just rely on these slides, but do your research. There are states where their local law says it's a violation to, even for nonprofit stuff, to call someone on the do not call list. So yeah, you're exempt from the federal, but a lot of states make it a separate violation of their own local rules to call a number on the national do not call list. So it may be a Louisiana violation. Yeah, that's a great example. Look at the top of the slide that I've got up here. Third bullet point. Professional fundraisers in those states are supposed to be scrubbing National DNC, because in those states they say, look, it violates our local law to call a National DNC number, and we don't have a nonprofit exemption. So it's not a violation under the federal rules, but you may have some state issues. They're absolutely right. Whoops.
Here's a good question. We touched on the ATDS, the expanded definition with the FCC order a little bit. We obviously didn't get into the whole discussion about what is not a dialer. This question is about what is the description of manual dialing? Does a Skype call qualify? Maybe we can kind of wrap things up with a little bit on what's being treated as a dialer. If you say it's manual, what does it really need to be manual? What you're seeing from the cases coming out, because I know there's been a couple recent ones.
Sure. Great kind of wrap-up question. It's somewhat complex, but let me give you my best couple minutes on this. We've all been very confused for several years about what an auto dialer is. The TCPA, the law itself, passed by Congress, only says that an ATDS is a system that uses a random or sequential number generator. Well, nobody does that anymore. Nobody does random sequential. Rather than go back to Congress and get them to change the definition of an auto dialer, when the FCC encountered predictive dialers, which don't do random sequential, they call from a list. But it is very automated, and you're calling a lot of lines at once, abandoning calls, etc. What the FCC did was, how do we figure out how to regulate that? How do we capture that under our existing law that just talks about random sequential? Well, what the FCC said was, what we really meant by that, or what the law really means, is anything that has a random or sequential number generator, plus anything else that could dial without human intervention, like a predictive dialer. So they just kind of made up some law, expanding the TCPA in their own way to capture predictive dialers. Well then, now there are all sorts of other flavors of dialers, power, progressive, preview, preview with multi-line, just avatar. There's just a million flavors of dialing technologies, ringless drop stuff. I mean, there's all sorts of things, Bluetooth, there's just tons of technology out there now. And what the FCC did in July of this year, just a few months ago, was expand their definition even further again. So in July, they responded to a big stack of petitions and a couple of letters that have been sitting on their desk for a while, asking for clarifications on some of these things. And when they addressed the petitions about auto dialers, they did a few crappy things. They refused to adopt a strict human intervention standard, meaning some of the petitions, including the petition of PACE, who we're members of, that petition had said, look, FCC, please clarify for sure that if the dialing system requires call-by-call human intervention, it's not an auto dialer, despite anything else present. And also clarify, as long as it doesn't have any auto dialer capacity now, present capacity to auto dial, that it's not an auto dialer. Well, in responding to the PACE petition and a number of others, they said no and no. We're not adopting the human intervention as the absolute standard, although we think it's still an important factor. We look at it on a case-by-case basis. Certainly, if your system has a lot of human intervention, that makes it look less like an auto dialer. But that's not the absolute single test. Also, they said we're refusing to adopt a present
There you go. You back?
Yeah, I've been on here, but I don't know why it cut out. What I was saying is that the FCC refused to adopt a present capacity standard, meaning if your dialing system could be quickly upgraded or enabled to auto dial in the future without significant time, cost, effort, then it's an auto dialer now just based on future capacity. So bottom line is you got to be really careful. If you thought you were exempt from scrubbing cells, even a year ago, post-July this year, the system you thought was not an auto dialer might be an auto dialer now. You need to be very careful. If you're calling cell phones with software and you don't have written consent, you need to make sure your system is truly not an auto dialer. It's a case-by-case determination. You look at how much human intervention there is. You look at all the things the FCC said in their July order. Could it call thousands of numbers quickly? Could it do predictive if you told it to? Could it be easily upgraded to auto dial, within a few hours or a few days or something? Just be very careful. Talk to the developers and find out about the capacity. Take that to the law firm of your choice and get an opinion letter, so you have something to wave in the face of the plaintiff's attorney or regulator who sends you the demand letter saying, why are you auto dialing cell phones?
Yeah, I think you really want to make sure that you do a legal review going in with the new order and the recent court cases. Make sure that you get a second opinion even.
Yeah.
There's just too much going on.
Yeah, I apologize, Ryan. You'd asked me about the recent cases. There have been several just in the last few months. I won't talk about each of them, but most of them, not all, but most of them have kind of sidestepped the July 10 order or construed it favorably. I think that there are going to be a lot more cases over this, and over time, courts will pay more and more attention to that order. But one of the cases, for example, just focused on human intervention and didn't even really address future capacity. But not every case. So be careful. You have to decide how aggressive you want to be when making decisions about whether you think your dialing system is an auto dialer. There are a lot of dialer vendors out there who are advertising that they have a TCPA compliant manual calling solution. I've looked at a lot of them, not all. Some of them seem like they are still auto dialers, and some of them seem like they are not, like they are manual, safe for calling cell phones type platforms. So case-by-case determination. Be very careful when you're auto dialing cell phones without consent. Make sure you're not using what the FCC would think is an auto dialer. Or you'll be calling me about a big class action.
I think that's a good way to kind of wrap things up. Going into the New Year holiday, I want to wish everybody a good holiday season, Merry Christmas, and Happy New Year. And hope that you can join us at some of our other compliance events and webinars in the near future. And we hope that we can offer you some positive advice, some innovative technology, and stay involved with your company in the next year with your compliance practices. Thanks again, Eric.
Absolutely. Thank you. Always a pleasure. Happy holidays, all. Bye now.